One objection to critical legal theory is it gives too much power to judges. Why? Because it allows them to insert their beliefs about what is good and bad policy into the interpretation of the law. Many people have argued that that is too much power to give to judges. For example, let's take a look at a scene from the television show Law and Order. The scene that I'm about to show involves a court case about someone who was already convicted of several counts of murder, escaped, and committed murder again. The issue was that the state of New York at that time did not have the death penalty, or in some sense they had the death penalty, but there was a problem with the kind of instructions that the judges were supposed to give to the jury. Right? That set of instructions had been struck down by the courts. And so they were trying to, at that time, prosecutors really couldn't argue for the death penalty. Okay. The district attorney finds a way that a district judge could approach things that kind of gets around that court decision, but it was questionable. Let's look at the debate in the appellate court between the district attorney and the defense attorney.
Her own private jury instruction in a death penalty case.
She's not imposing it, Counselor. She's merely allowing the prosecution to seek it.
But Judge Desmond is ignoring the deadlock instruction required by statute and crafting her own. She can't break the law in order to fix it.
But the law was already broken.
Precisely, Your Honor. The status of the law is uncertain. The people are simply asking if New York has the death penalty or not.
And the answer is no, not under the current statute.
Now opposing counsel has exceeded his authority. The power to answer that question lies with the courts. It's called judicial review.
This is judicial activism.
Watch yourself, Counselor.
The Manhattan DA and Judge Desmond are trying to circumvent the legislature.
Despite Laval, capital punishment is still valid in this state. And what's the point of having the death penalty if we're afraid to use it on a man like Leon Vorgich?
I brought up this example because it points to a couple of the terms that people use and the arguments they use. Notice that one of the attorneys was talking about judicial activism. Okay? That's a critical term that people often use when they see judges as going too far in striking down a law, right? Apparently because the judge doesn't like the policy implications of the law rather than strictly following precedent, etc. There's also some talk about the legislature. Okay? There's a concern that the legislature has been too slow in dealing with things, so judges are getting involved. But some people question whether that's a good thing. For whatever reason, this is frequently associated with right-of-center politics. At least a common understanding is that it tends to be the case that people on the right of center in the United States tend to raise objections to judicial activism, whereas left of center politicians and thinkers apparently tend to move more in the direction of saying, well, it's unavoidable, right, and acceptable, or saying judges to the right of center do the same thing, rather than sharing the objection to judicial activism. Now, that's certainly not true at least not true across the board in the philosophical debate. There's a lot of people in the philosophical debate who are left of center who have reservations about judicial activism. In fact, this became a political issue in the 2000 elections. Right? Basically, there was a question about who the different candidates might appoint to the Supreme Court. Here's what Al Gore said, and here's what George Bush said in response.
It's wrong to use a litmus test, but if you look at the history of a lower court judge's rulings, you can get a pretty good idea of how they're going to interpret questions. Now, a lot of questions are of first impression, and these questions that have been seen many times come up in a new context, and so. But this is a very important issue because a lot of young women in this country take this right for granted, and it could be lost. It is on the ballot in this election. Make no mistake about it.
I'll tell you what kind of judges he'll put on there. He'll put liberal, activist judges who will use their bench to subvert the legislature. That's what he'll do.
That's not right.
New subject, new question.
When Bush said that, it was something that would definitely have resonated with his base and perhaps with other people in society. Now you might ask, what's the big deal about judicial activism? Why are people concerned about judges inserting their policy preferences? That's a very good question. Let me explain it briefly. Judges, at least in the United States, serve for life. They are insulated from public opinion in certain ways. And there are reasons why we do things that way. Basically, the concern is that there are dangers in making everything subject to the whim of the electorate. Okay? That means that people that are unpopular or very unpopular opinions will not be treated fairly. Right? And that is a reason for concern. At the same time, there are a lot of people that think that fine details of public policy should be responsive to the public's concerns and to oversight by the public. And of course, the way that we do that is by having the legislature and the executive regularly elected. On the federal level, members of the House are elected every 2 years. Members of the Senate are elected every 6 years. So there's supposed to be checks and balances here. So people that strongly object to what they call judicial activism are more or less see things as follows. It's a good thing to have a framework that sets limits on what laws can be passed. But it's very important that that be a general framework with its own set of rules, precedents, etc., and that it have limits to the power of judges to strike down particular laws. They're supposed to police that framework, not make personal judgments about the fine details of policy. So they're supposed to follow these rules, precedents, the Constitution, the common law, etc., about the limits of how far the legislature should go, but leave a substantial amount of leeway within those limits for the legislature to choose what they think is good and bad policy. So the concern is that things get very dangerous when we give judges too free of a hand to insert their own views about good and bad policies rather than simply policing some very broad, right, relatively limited restrictions on what the law can be. So the concern is that because critical legal theory says that judges should have a freer hand to promote the policies that they believe are progressive rather than oppressive, then they have too much of a free hand to impose their own policy preferences in the guise of law.